Hi everyone, I'm JD Hoovener, and welcome to the Bold Today Show, where you, the inventor, entrepreneur, or business owner, get your daily dose of inspiration to make the world a better place. Thanks for joining today, and this is part 2 of our 5-part series about discussing the services that we love and hold dear and be able to serve our clients with. Yesterday we talked about the patentability search opinion, and we talked about how it's important in making that solid business decision about how to move forward, right? Whether your invention is new in the whole world, right? Making sure you know what databases and you can trust a professional like our team to take care of that and make sure you're making a good decision when you decide to put that time and money into that patent application filing. Today we're going to talk about that application and one particular type of application called the Provisional Patent Application. You may have heard this term floated around in forums like even on a famous TV show, ABC's Shark Tank. And it's people get confused about what the provisional patent application means. And I hear the term, hey, I've got a provisional patent on that. And that annoys me. And it probably annoys every other patent attorney out there because there is no such thing as a provisional patent. It is just an application for a patent. So there are no rights that get vested when you just simply file an application, right? And so you've got to wait, of course, until you file the non-provisional patent application, send it into the examiner, then they approve it and get granted. That's when rights actually get issued, and you've got some legal authority to prevent anyone else out there in the market from making, using, selling, or importing. So I want to dig in today a little bit about what the provisional patent application is, some high-level discussion. If you want to look for more information, you've got to go online to boldpatents.com. There you're going to find a lot of information, of course, on the website. But what you'll see is a link to our book called Bold Ideas, The Inventor's Guide to Patents. And in there, I'm just going to make a quick reference to Chapter 14, where a deep discussion is had about what the difference is between a provisional and a non-provisional patent application. So tomorrow we're going to talk more about non-provisional applications, but today we'll spend a little bit more time on provisionals. All right, so at a high level, a provisional application is just that. It's a placeholder. Its main objective is to help you with setting in a filing date. Because based on the law as it is now, it is not first to invent, right? There could be someone out there in the world that has the same invention as you. And what matters is not who invented first, but who files it first. So that's what the provisional filing date is for. And in many cases, that's why someone would submit a provisional, because they're not quite sure what the claims are. In a provisional, you need to submit a full specification, which is, of course, the full written description of an invention. And that must be enabled. Per Section 112 of the law, the written description must be in such a description such that someone like you, an inventor in your field, needs to be able to pick up that written description along with the drawings and be able to make and use your invention. So don't take me lightly. The description needs to be in great detail. But the provisional is informal. The drawings can actually be hand-drawn, and it can be put together in a fairly streamlined fashion without too much rigor. As I said before, there's no claims in a provisional, and the drawings can also be informal. So it takes our team about half as much effort as it would to do a non-provisional patent application, which we'll get to later. So the key to a provisional is that you have up to 1 year from filing the provisional to follow it up with a non-provisional patent application. That one year window is non-extendable. You've got to make sure you file that within 1 year if it's an application that you want to maintain. If after that 1 year and that goes by, your application gets abandoned, and if you've published it to the public, you now have no recourse to be able to claim that as your invention. It's part of the public domain. So don't let that happen to you. Please get with us if you have any questions and you're ready to get going on your provisional application. To boldpatents.com. There you'll see a link to schedule your own 30-minute consultation with one of our patent attorneys. I'm JD Hoovener. I'm your host of the Bold Today Show. Hope you have a wonderful day. Go big, go bold.